Welcome to News Hour by DLC, your one-stop destination for the latest and most impactful updates from the legal world. From landmark rulings to policy shifts shaping the justice system, DLC brings you in-depth coverage, expert insights, and analysis that matter. Stay informed, stay ahead because in law, every verdict counts. Today is 27th February 2025 and we bring you news that matters. The first news for today is as follows. The Supreme Court of India has directed the Union government to consider establishing a compensation policy for individuals who have died due to adverse effects following COVID-19 vaccination. This directive came during a hearing on February 25, 2025, where a bench comprising Justices Vikram Nath and Sandeep Mehta addressed a special leave petition challenging a Kerala High Court interim order. The High Court had previously instructed the Ministry of Health and Family Welfare and the National Disaster Management Authority to develop guidelines for compensating families of those deceased from vaccine-related adverse events within 3 months. In response, Additional Solicitor General Aishwarya Bhati, representing the Union government, requested 3 weeks to deliberate on the court's suggestion, which the bench granted. The Supreme Court emphasized that deaths resulting from COVID-19 and those linked to vaccinations should not be viewed separately, noting that the vaccination campaign was an integral part of the pandemic response. Previously, the Union government had maintained that it could not be held liable for compensation in cases of death or injury resulting from COVID-19 vaccinations, asserting that vaccination was a voluntary act and that adverse events following immunization did not qualify as a disaster under the Disaster Management Act 2005. The Supreme Court has scheduled the next hearing for the 18th of March 2025 to further address the matter. Next news. The Supreme Court of India has ruled that arrests under the Goods and Services Tax (GST) Act cannot be made solely to investigate whether a cognizable and non-bailable offense has been committed. The court emphasized that such arrests must be based on a reason to believe supported by tangible material evidence that the individual has indeed committed a non-bailable offense as specified under Section 132(5) of the GST Act. A bench comprising Justices Sanjeev Khanna, M. Sundaresh, and Bela M. Trivedi highlighted that the power to arrest is distinct from the necessity to arrest. They noted that the GST legislation does not mandate arrest for the completion of an investigation. Arrests should not be routine but must be predicated on credible evidence and substantial material. The court further clarified that the commissioner must record the reasons for such belief, referencing specific material that substantiates the alleged offense. This ensures that the decision to arrest is not based on mere suspicion but on verifiable evidence that can withstand judicial scrutiny. This ruling came in response to a series of petitions challenging the constitutional validity and interpretation of certain provisions within the Customs Act and the GST Act. The petitioners argued that the arrest provisions were being misused, leading to coercion and harassment without due process. The Supreme Court has reserved its verdict on these challenges, indicating that it will provide a detailed judgment addressing the legal principles involved. In the interim, the court's observations serve as a directive to GST authorities to exercise their arrest powers judiciously, ensuring that individual liberties are not compromised without substantial justification. Next news. The Supreme Court of India has ruled that under the Goods and Services Tax (GST) Act, authorities are permitted to authorize arrests even before the final determination of tax liability provided there is a sufficient degree of certainty regarding the commission on offense. The court emphasized that the commissioner must record explicit reasons based on concrete material and evidence to justify such an arrest. This decision clarifies that while formal assessment proceedings typically quantify the amount of tax evaded, there can be instances where even without a formal assessment order, the authorities possess enough evidence to ascertain that an offense under Section 132(1) or the GST Act has been committed. In such cases, the Commissioner is empowered to authorize an arrest after documenting clear reasons founded on the available material. The ruling came in response to a series of petitions challenging the constitutional validity of certain penal provisions within the Customs Act and the GST Act. Petitioners argued that arrests should not be made prior to the final determination of tax liability. However, the Supreme Court's judgment establishes that in cases where there is substantial evidence suggesting the commission or non-bailable offense under the GST Act, arrests can be justified even before the completion of formal assessment procedures. This judgment delineates the scope of arrest powers under the GST framework, underscoring the necessity for explicit evidence-based reasons before depriving an individual of their liberty in tax-related offenses. Next news. In a landmark ruling on February 27, 2025, the Supreme Court of India has determined that anticipatory bail applications are maintainable for offences under the Goods and Services Tax (GST) Act. This decision overturns previous judgments that denied such relief to individuals accused of GST violations. The three-judge bench comprising Chief Justice Sanjeev Khanna, Justice M.M. Sundaresh, and Justice Bela M. Trivedi specifically overruled earlier decisions in State of Gujarat v. Chudamani Parmeshwaran Iyer and Bharat Bhushan v. Director General of GST Intelligence. These prior rulings had asserted that individuals summoned under the GST Act could not seek anticipatory bail and that their sole recourse was to file a writ petition under Article 226 of the Constitution. In the case of Radhika Agarwal vs. Union of India, the court addressed multiple issues related to arrest procedures under the GST and Customs Acts. Chief Justice Khanna, authoring the judgment, emphasized that the power to grant anticipatory bail arises when there is a reasonable apprehension of arrest. This authority, vested in courts under the Criminal Procedure Code, upholds the fundamental right to life and liberty enshrined in Article 21 of the Constitution, serving as a safeguard against unwarranted detention. The bench further clarified that it is not mandatory for an individual to wait until an FIR is filed to seek anticipatory bail. As long as the apprehension of arrest is based on clear facts and a reasonable basis, courts are obligated to consider such applications. This stance aligns with the principles established in the 1980 judgment of Gurbaksh Singh Sibia vs. State of Punjab and reaffirmed by a constitution bench in Sushila Agarwal and others v. State, NCT of Delhi, and another. This ruling signifies a pivotal shift in the judicial approach Two bail provisions under tax laws reinforcing constitutional protections against arbitrary arrest and ensuring that individuals have access to anticipatory bail when facing potential detention under the GST framework. Next news. In a significant ruling on February 25, 2025, the Supreme Court of India affirmed that the public procurement policy for micro and small enterprises MSEs Order 2012, issued under the Micro, Small and Medium Enterprises Development MSMED Act 2006, holds the force or law and is enforceable. The court emphasized that while the MSMED Act and the 2012 Procurement Order do not grant an individual MSE an enforceable right to secure contracts, the statutory authorities and administrative bodies established under this framework are endowed with enforceable duties. These bodies are accountable for their actions and decisions, making them subject to judicial review. The bench, comprising Justices P.S. Narasimha and Sandeep Mehta, underscored that in matters related to the implementation of an act or its policy objectives, the primary responsibility of constitutional courts is to ensure that the relevant authorities are functioning effectively and efficiently. This approach leverages the expertise of domain-specific statutory bodies, promoting informed decision-making and facilitating real-time assessments of policy implementation. Such oversight enables necessary adjustments in future policymaking. The court clarified that judicial review in this context focuses on ensuring the proper constitution and effective operation of bodies such as the National Board for MSMEs, the Advisory Committee, the Facilitation Council, the Review Committee, and the Grievance Cell. While these bodies are held accountable through judicial oversight, the formulation and execution of specific policies and decisions remain within their purview. This ruling arose from a petition by a micro-enterprise specializing in a unique medication for severe fungal infections. The petitioner contended that despite efforts to participate in public procurement processes, it faced repeated disqualifications due to minimum turnover clauses in government-issued tenders, which it could not meet due to its micro-scale operations. The Supreme Court's decision highlights the enforceability of the 2012 Procurement Order and reinforces the accountability of statutory bodies overseeing its implementation, ensuring that MSEs are afforded fair opportunities in public procurement. Next news. In a landmark decision, the Supreme Court of India has ruled that pension benefits cannot be denied to a retired government employee if their period of unauthorized absence has been regularized as extraordinary leave. The court emphasized that once such absence is regularized, it cannot be considered a break in service for the purpose of denying pensionary benefits. The case involved Jaya Bhattacharya, a former lower division assistant in the office of the Block Development Officer Jharagram, West Bengal. She was absent from duty between the 29th of June 1987 and the 12th of July 2007, alleging that she was prevented from performing her duties. The authorities treated this period as unauthorized leave. After multiple legal proceedings, her absence was regularized in 2011 by treating it as extraordinary leave. However, she was denied pension benefits on the grounds that this period did not count as qualifying service. A bench comprising Justices B.R. Gavai and Prashant Kumar Mishra observed that the failure of the authorities to conduct a departmental inquiry, despite directives, could not shift the burden onto the appellant to prove her absence was justified. The court stated that denial of pensionary benefits must be based on specific rules permitting such action. In this case, since the service during the period of absence was regularized by granting extraordinary leave, it could not be treated as unauthorized leave for denying pension benefits. Consequently, the Supreme Court directed the authorities to finalize Bhattacharya's pension within 3 months, clarifying that she would not be entitled to arrears. This ruling underscores the principle that regularization of service periods, even those involving prolonged absence, should not adversely impact an employee's entitlement to pension. Next news. In a decisive judgment, the Delhi High Court has granted a permanent injunction in favor of Castrol Limited, restraining engine oil manufacturers from infringing upon Castrol's trademarks and trade dress. The court also awarded 20 rupees lakh in costs and damages to Castrol, underscoring the deliberate attempt by the defendants to mislead consumers by replicating Castrol's distinctive packaging. Justice Mini Pushkarna observed that the defendants' packaging closely mimicked Castrol's two-tone green and white color scheme, layout, and overall get-up, creating a deceptive similarity likely to confuse consumers regarding the origin of the products. The defendants operating under the brands Kapil Auto Workshop and Macvol Lubricants were found to have used nearly identical labels and design elements, including a circular green highlight reminiscent of Castrol's branding. The case arose when Castrol discovered that defendants were advertising and selling engine oils, coolants, gear oils, and lubricants bearing marks and packaging deceptively similar to Castrol's ACTIV and Actibond trademarks. Investigations revealed that the defendants promoted these infringing products through Facebook profiles named Macvol Lubricants and Macvol Engine Oil, as well as a group titled All India Lubricant Manufacturers. A court-appointed local commissioner conducted a raid at the defendants' premises in Rajasthan, uncovering multiple boxes of counterfeit products bearing the infringing marks. The court's ruling emphasizes the importance of protecting established brands from infringement and serves as a stern warning against attempts to capitalize on the reputation and goodwill of well-known trademarks. Next news. Delhi High Court has reserved its verdict on a plea by Delhi University challenging a Central Information Commission (CIC) order that directed disclosure of Prime Minister Narendra Modi's Bachelor of Arts degree records from 1978. Solicitor General Tushar Mehta, representing the university, argued that such information is personal and held in a fiduciary capacity, asserting that public curiosity does not equate to public interest. Conversely, senior advocate Sanjay Hegde, representing the RTI applicant, contended that academic qualifications of public figures are matters of public interest and should be disclosed. Next news. The Delhi High Court has been informed by the Union government that guidelines for determining child custody disputes are in the process of being formulated and are expected to be finalized within 2 to 3 months. This development was communicated during the hearing of a suo motu petition initiated by the High Court, which seeks the establishment of standardized procedures for resolving child custody matters. The division bench, comprising Chief Justice N.V. Anjaria and Justice M.I. Arun, directed the union government to submit an affidavit detailing the timeline and processes involved in finalizing these guidelines. The court has scheduled the next hearing for the 19th of March to review the progress. The suo motu petition emphasizes the complexities arising from cross-border migrations and the resultant personal conflicts affecting children entangled in custodial battles. It highlights the necessity for a uniform definition or natural guardian across various personal laws, and advocates for guidelines that incorporate scientific and professional insights into a child's psychological well-being. This initiative underscores the judiciary's proactive approach in safeguarding children's interests amidst matrimonial disputes, aiming to provide them with a stable environment conducive to their development. Next news. In a recent hearing, theUnd High Court addressed concerns regarding the state's Uniform Civil Code (UCC) provisions, particularly those mandating the registration of live-in relationships. The bench, comprising Justice Manoj Tiwari and Justice Ashish Naitani, observed that female partners in such relationship are often more vulnerable. Solicitor General Tushar Mehta, representing the state government, informed the court that the UCC was implemented following extensive public consultation. He emphasized that the provisions related to live-in relationships were specifically designed to protect women, acknowledging their vulnerable position in these arrangements. The court was hearing public interest litigations challenging aspects of the UCC, with petitioners arguing that mandatory registration could lead to increased surveillance and potential harassment. Advocate Vrinda Grover contended that while the UCC aims to safeguard women's rights, certain provisions might inadvertently heighten risks for women and couples not conforming to traditional norms. Justice Tiwari acknowledged the evolving societal acceptance of live-in relationships and noted that the law seeks to adapt to these changes by ensuring the protection of women and children involved. The court's deliberations continue as it examines the balance between safeguarding individual rights and implementing uniform legal standards. And the final news for today is as follows. In a significant ruling, the Kerala High Court has granted police protection to an interfaith couple from Dahand who fled to Kerala due to threats from their families and subsequently married. The court directed local authorities to ensure the couple's safety and prevent any attempts to repatriate them during the ongoing legal proceedings. The petitioners, Asha Verma and Mumid Ghalib, both hailing from Ramgarh district in Dhand, had been in a relationship for a decade. Facing familial opposition, they relocated to Kerala on February 9, 2025, and solemnized their marriage according to Islamic rites in Kayamkulam, Alappuya district on February 11. Despite their union, they continued to receive threats from their families, with Verma alleging coercion to falsely claim abduction. Justice C.S. Dias, presiding over the case, emphasized the couple's constitutional right to reside anywhere in the country and marry freely. The court's order mandates the station house officer to provide adequate protection to the petitioners and ensure they are not forcibly relocated during the pendency of the writ petition. This ruling underscores the judiciary's commitment to upholding individual rights against societal and familial pressures, particularly in matters of personal relationships and marital choice. Thanks for listening and consider subscribing to the channel. Well, that's all for today. Keep listening to Legal News by DLC.